There's a lot of talk lately about a new federal minimum wage. I thought this would be a good time not only to ask the question, is it constitutional, but to look at a couple of Supreme Court cases about it from our history. So we'll do that next on the Constitution Study.
One thing you have to know wherever you make your stand came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study. That's right, this is where we read and study the Constitution. We teach the rising generation to be free. I hope you're enjoying these videos. Hey, I'm going to be in Nashville. There's a Teach Them Diligently Homeschool Conference. So if you're going to be in Nashville, I think it's the 18th, 19th, and 20th of March, and you're going to be at this event, well, please stop by my booth. I'd love to say hello. I'd love to actually shake your hand, meet you in person, and maybe talk about what you think about the channel. What can I do differently? What can I learn? I would just love to meet you in person, so that'd be a great opportunity to do that. You can find out more at the website constitutionstudy.com. And as always, I would really appreciate it if you would share these videos with friends and family. Put them on your social media. It's absolutely free. I blast it wherever you can. The more people who see this information, I think, the better we're going to become as a nation. And we really need the help right now. And of course, if you head to the website, you can always, sign up for the newsletter, click to get your free book. Maybe head over to Constitution Scholars and find out more about what's going on, not just in this country, but what's going on in your state. And I'll talk a little bit more about that at the end of this video. But for now, let's talk about a federal minimum wage. While my goal is not an extensive review of minimum wage laws in this country, their existence is not exactly new. Back in 1918, the Congress passed a law that became known as the Minimum Wage Act of September 19th, 1918. I say it became known because the title of the bill is, well, it's rather lengthy. Quote, "Enact to protect the lives and health and morals of women and minor workers in the District of Columbia, and to establish a minimum wage board and define its powers and duties, and to provide for the fixing of minimum wages for such workers and for other purposes." Quite a mouthful, huh? Now, some of you may be asking yourself why Congress was making laws for Washington, D.C. Well, because as a federal city and seat of the federal government, the District of Columbia is run by Congress. From Article 1, Section 8, Clause 17 of the Constitution, we read, quote, "To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may by secession of particular states and the acceptance of Congress become the seat of the government of the United States." Now, as the full title states, the legislation would establish a board to fix minimum wages for women and minors. This board was empowered to, among other things, quote, "that the board shall have full power and authority, 1, to investigate and ascertain the wages of women and minors in the different occupations in which they are employed in the District of Columbia, 2, to examine through any member or authorized representative any book, payroll, or other record of an employer of women or minors that may in any way appertains to or has bearing upon the question of wages of any such women or minors, and 3, to require from such employer full and true statements of the wages paid to all women and minors in this employment." Section 9 goes on that the board is hereby authorized and empowered to ascertain and declare in the manner hereafter provided the following things: A, standards of minimum wages for women in any occupation within the District of Columbia, and what wages are inadequate to supply the necessary cost of living to any such women workers to maintain them in good health and to protect their morals, and B, standards of minimum wages for minors in any occupation within the District of Columbia, and what wages are unreasonably low for any such minor workers. Does any of this sound familiar? This is the same reasoning used to establish minimum wage laws today. Now, I'm not going to take the time to deal with the Fourth Amendment violations of searches without a warrant, but focus on the issues in these cases. Let's start with Adkins versus Children's Hospital. See, D.C.'s Children's Hospital sued Jesse Adkins, a member of the Wage Board, claiming that the law violated their freedom to contract protected by the Due Process Clause of the Fifth Amendment, which reads, quote, "No person shall be deprived of life, liberty, or property without due process of law." Now, while there is no specific contract protection in the Fifth Amendment, you can only be deprived of your liberty to contract as you see fit by due process. Continuing from the Adkins case, quote, "that the right to contract about one's affairs is part of the liberty of the individual protected by the Fifth Amendment is settled by repeated decisions of this court. Within this liberty are contracts of employment of labor. In making these, generally speaking, the parties have equal right to obtain from each other the best terms they can by private bargaining. Legislative abridgment of this freedom can only be justified by the existence of exceptional circumstances. The Minimum Wage Act of September 19, 1918, in assuming to authorize the fixing of minimum wage standards for adult women in an occupation in the District of Columbia, such standards to be based wholly upon what a board and its advisors may find to be an adequate wage to meet the necessary cost of living for women workers in each particular calling and to maintain them in good health and protect their morals, is an unconstitutional interference with the liberty to contract. Seems pretty straightforward. You have the liberty to contract, including for employment. And such liberty cannot be deprived without due process of law, which the Free Legal Dictionary defines as, quote, an established court for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. Now, just a few years later, though, the Supreme Court would backtrack completely on this opinion. See, in 1913, the state of Washington passed an act called the Minimum Wages for Women. This act set minimum wages for women and minors within the state. Similar to the Washington, D.C. law, this law established a board to set wages and conditions under which women and minors could be employed. Now, Elsie Parrish, a chambermaid, sued her employer to recover the difference between what she was paid and the state's minimum wage. Now, the trial court found for Ms. Parrish's employer, but that decision was overturned by the state of Washington Supreme Court in Parrish v. West Coast Hotel Company. The West Coast Hotel Company appealed the opinion of the Washington State Supreme Court, relying on Adkins versus Children's Hospital opinion. They also complained that the law violated the 14th Amendment's prohibition on states making laws that deprive someone of liberty without due process of law. Quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. Now, the case was decided by the Supreme Court in 1937, just shy of 14 years after the Adkins case. In this instance, the court upheld Washington's minimum wage law. The reason why is very instructive. Quote, deprivation of liberty to contract is forbidden by the Constitution if without due process of law. But restraint or regulation of this liberty, if reasonable in relation to the subject and if adopted for the protection of the community against evils menacing the health, safety, morals, and welfare of the people, is due process. As in the Adkins case, the court notes that deprivation of liberty to contract without due process is forbidden by the Constitution. However, the court then invents the idea that restraint or regulation of your liberty is permissible if it is reasonable. The problem is, nothing in the Constitution says the courts can overrule anything, even if they find it reasonable. Quote, the constitutional provisions invoked is the Due Process Clause of the 14th Amendment governing the states, as the Due Process Clause invoked in the Adkins case governed Congress. In each case, the violation alleged by those attacking minimum wage regulations for women is deprivation of freedom of contract. What is this freedom? The Constitution does not speak of freedom of contract. It speaks of liberty and prohibits the deprivation of liberty without due process of law. In prohibiting that deprivation, the Constitution does not recognize an absolute and uncontrollable liberty. Liberty in each of its phases has its history and connotations. But the liberty safeguarded is liberty in a social organization which requires the protection of law against the evils which menace the health, safety, morals, and welfare of the people. Liberty under the Constitution is thus necessarily subject to the restraints of due process, and regulation which is reasonable in respect to its subject and is adopted in the interest of the community is due process. As I've already mentioned, the Constitution does not mention freedom to contract, but the freedom of restraint of liberty except by due process of law. The West Coast Hotel Court not only added the power to regulate your rights, it claimed the Constitution, quote, does not recognize an absolute and uncontrollable liberty. Now, while correct so far, the only limitation the Constitution places on your liberty is due process and nothing else. This court was correct when they wrote the phrase, quote, liberty under the Constitution is thus necessarily subject to the restraints of due process, close quote. which is constitutional. When they added, quote, and regulation which is reasonable in relation to its subject and adopted in the interests of the community is due process, quote, well, not only were they wrong, they were blatantly and flagrantly violating the Constitution, their oath of office, and the very standards of good behavior that are required for them to hold that position. The Constitution does not grant to courts the authority to rewrite the Constitution. Neither does it grant them the power to reinterpret it as they see fit. The Supreme Court, and in fact all courts, are bound to the actual words of the Constitution, at least according to Article 6, Clause 2. Quote, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of the United States to the contrary, notwithstanding. Now, in his first inaugural address, George Washington stated, quote, and since the preservation of the sacred fire of liberty and the destiny of the Republican model of government are justly considered as deeply, perhaps as finally staked on the experiment entrusted to the hands of the American people. By allowing this abridgment of our rights and by allowing those we hire to exercise our sovereign power to let this violation pass, we have allowed not only the courts but government at all levels to place themselves above the supreme law of the land. We have allowed those governments to transform themselves from servants of the people to their masters. We have extinguished the sacred fire of liberty and crushed the Republican model of government that was entrusted to us. So when we slump under our onerous burdens of overbearing government regulation, when we grope in the dark searching for the light of liberty, when we long for the days of self-government, remember, it was we the people that let the fire go out. I'm amazed sometimes how ignorance of the Constitution has let government do so many things. How the court suddenly decided that a process to protect individual rights was dictating to them what they must pay, dictated to them minimums for their contracts. That protects your rights by taking away your right to contract as you see fit. But you see, the court found that because that's what they wanted. They wanted a minimum wage. Got to remember, courts are government officials. We should not be surprised when courts side with the government. They actually get paid by the government. They're part of the government. Well, Adkins was right and looked at it and said, listen, the federal government has no authority to do this. The Children's Hospital case found the same court, I don't know if there were different members or not, looked at it and said, oh, but we can regulate it. Well, there's nothing in the Constitution about regulating rights. Therefore, they violated the 10th Amendment. They assumed a power to regulate something that was not delegated in the Constitution. Therefore, they violated their oath of office, which pretty much is a definition of bad behavior. And here we are in 2021, still living with the consequences of bad, erroneous, terrible decision of the Supreme Court. You know, people often talk about the Marbury versus Madison case as the time that the court assumed the power to review laws. Here it is. It's actually Marbury versus Madison. The court said, listen, we cannot do this because the Constitution doesn't allow it. Here we have an example of the court saying, sure, you can do that because we'll make up a right to make it happen. We'll make up language for the Constitution. We'll include something it just does not say. And because of the ignorance of the people, both then and now, it keeps going on. So what are we to do? Well, it's about time we start talking, not just to our House rep. Start talking to your county officials. Start talking to your state officials. Start pointing out to them that the Constitution, this is a violation of the Constitution. It is a fraud. And it's about time they stand up and say, you know what, federal government, you have no right to tell us about a minimum wage law. You have no right to deprive our citizens of the liberty to contract as they see fit. And since the states aren't allowed to deprive you of liberty without due process of law either, guess what? Minimum wage laws are illegal. They're void. At least that's what Alexander Hamilton and the Chief Justice who wrote the opinion of Marbury versus Madison said. Acts of Congress repugnant to the Constitution are void. They're void. They don't exist. They're empty. They're meaningless. Why do we keep following them? because we're ignorant. That's what we're trying to do here, is bring the light of knowledge into the darkness of ignorance. To show people that they are not servants of government. They are supposed to be its master. To recognize that your rights and the Constitution supersede whatever comes out of D.C. or whatever comes out of your state house. See, by learning this, by understanding this, we can maybe start living like a free people again. Not sitting there wondering, what some government agent is going to tell you have to do. I don't care if you don't have the authority to do it. I'm going to ignore it. Will some of us go to jail for that? Yeah, probably. In fact, almost assuredly. But what is your liberty worth? What is the liberty of your children and your grandchildren worth? Do you want to live in a land where government gets to tell them what they can say and what they can hear and what they're allowed to do? Oh, it's happening. Look at the news. What are we going to do? Hopefully what you'll do is you take this video or you take the article and you'll share it. You'll send it to friends. You'll send it to family. You'll start a discussion, a debate about, wait a second, is this really constitutional? And then you'll contact your state and your county and your city officials and say, wait a second, this is void. See, I can prove it. Go to the website, constitutionstudy.com. Look for Knowing Your Rights. Just search for Knowing Your Rights. You'll see a placard I did talking about how these orders and these laws are void. If you want to find out more, head to the website constitutionscholars.com. There I'll show you information not only about how you can learn more about the Constitution, but you can find others that are interested as well. And not just the U.S. Constitution. There's a group for each and every state. So you can join your state group, find out more about what's going on in your state, find out more about the Constitution of your state. Maybe you'll head over to the shop. You can pick up one of the classes. There's a free U.S. Constitution class you can sign up for. Online class, 12 weeks, absolutely free. It's put on by the Institute on the Constitution. Find out more, again, at constitutionstudy.com. But most of all, whether you support this financially or just support us by sharing this information, that is what makes a difference. Get to know your friends and neighbors and let them access this information. If you have a question, ask it on the website. But most of all, keep doing the good work. Keep fighting the good fight. Keep learning about the Constitution. Learn to recognize when your rights are being violated, being prepared to defend and assert them. And come back here next time for the Constitution Study.
There's one thing you have to